me bring in defense attorney, former head prosecutor Bob Bianchi. Bob, of course, thank you for joining me, my friend. Listen, pretrial hearings like this one, a suppression hearing, they're the meat and the potatoes of the trial, in my opinion, because we both know that's when the decisions are made as to what's really going to come out in trial. Trials, I think, can be won and lost. And here, they're trying to say the voluntariness of the defendant's statements. Defense saying, no, they weren't voluntary, they don't come in. What are your thoughts?
Well, firstly, good afternoon, Judge Ashley. Thank you for having me on. And my thoughts are, I'm wondering whether the prosecutor is making a tactical mistake here. So let's break this down legally, first of all. The word voluntariness, Miranda requires, and the reason they were talking a lot about custodial interrogation, was she in custody? That's part one. And was she asked a question where she gave an incriminatory response? This is why you hear them talking about, well, she was in jail, so she clearly was in custody. You hear them talking about she was in a room and she wasn't free to leave. That's a typical question a defense lawyer would use to argue that they're not in custody. And then were they asked questions that elicited an incriminatory response? Let's go to the last one. The lawyers are saying there was no incriminatory response. The only way that the statement against interest is an exception to the hearsay rule, which allows a defendant's statement to be admitted in evidence, is that it is incriminatory. Under the evidence rules, judges, you know, what it's saying is that people don't make incriminatory statements unless they're typically truthful. So I don't even understand how it's being admitted in the first place. Secondly, I have seen prosecutors make the mistake thinking that simply because somebody speaks that's a defendant, they want to introduce that statement into the record before the jury, not thinking tactically that that may prevent the defendant from having to take the stand because you're giving the defense through the statement, which appears is what's happening here because she hasn't said anything incriminatory. So I hope I didn't get too convoluted with that, but I don't understand. Many times as a prosecutor, my last murder case as a prosecutor, I got the judge to agree that Miranda was not violated, which may have been violated here, and I got the judge to agree that it could be admitted in evidence, but I did not admit it in my case in chief because I knew if I did, the defendant would not take the stand. By not admitting that statement, the defendant was forced to the stand, and I was able to use that statement to cross-examine him for 3 days, which really destroyed his case. Does that make sense, Judge?
It does, and I love it, because you get into the legal weeds with me, which I really appreciate. But basically, yes, that example sums it up. What you're saying is she didn't say anything that's going to hurt her. So why in the world is the prosecution even bothering with all of this and saying, let's have her statements come in? Right? Strategically.
Yeah.
So I think it's strictly a strategic decision, and you're suggesting maybe it's not the right one by the prosecution.
You know what I hear myself saying already is I love trials. This is why I love the tactics of trials. I already, as a prosecutor, have to think, what is the defense going to say about this? And as a defense lawyer, I'm thinking, we're kind of like schizophrenic in how we approach a case. I can hear myself as a defense lawyer saying, they needed that statement. That's why they gave it to you. They gave you the statement because that's the best they've got. And it was nothing. Ladies and gentlemen, the jury, tell me where in the statement from page 1 to page 42.5 did she admit or confess to any crime? That's how weak this case is. Otherwise, the prosecutor wouldn't have used that statement, but they needed to, and to try to convince you that it said something that it didn't. It nicks the prosecutor's credibility.
And it's wild to me that they are having this hearing to try to get the statement in, because I too question the real need for it. Force her to get on the stand if she wants to testify. Glad to still have you, Bob, because listen, let's talk about what the judge just did. This isn't always the outcome, but he specifically said that this is going to be excluded. It would not be proper to give it to the jury, to give it to the jury, because she asked to at least consult with her attorney, and they denied her. That's a basic fundamental right, and the judge says you can't do that. I'm not letting this in.
Judge, I sat here kind of in disbelief. I got a lot of things going on in my head right now. I'm confused, okay? First of all, it's a no-brainer. The judge's ruling is absolutely correct. She asked for a lawyer, and you are to stop questioning immediately, and you are to scrupulously, quote-unquote, honor a person's invocation of their attorney. So what this cop did was clearly a violation of her Miranda rights, both in the beginning and during the statement. So the remedy for that is suppression. But I've got to ask myself the question, Judge, who won here? Because I now found out that there was an 84-page statement of her denials. And if the state was going to introduce the 84 pages of her denial, like I said earlier, the defense does not have to put the defendant on the stand. The statement speaks for itself. It was a tactical error for the prosecutor to even be seeking to introduce it in the first place. Now, last point I got to make here, Your Honor. Judge, imagine you on the bench, you're in the middle of ruling and disallowing a statement, and the prosecutor pops up and decides to throw out that, well, the lawyer was contacted afterwards, throwing a whole monkey wrench into the judge's decision, and the lawyer said he didn't represent her, which has no relevancy to the fact that she invoked her right to an attorney. So why am I mentioning this, Judge Ashley? You and me both know when she jumped up and said that has no relevance, and after the judge already ruled, amateur hour.
Yeah, so many things I'm thinking about. But let me just ask you this theoretically, because we know next the defense is going to be arguing a motion to suppress insulin that was found in her refrigerator. Could it be, Bob, that she said something during that interview about insulin which led them to get the arrest warrant, and the defense is saying if that statement's out, therefore, too, is the warrant with the insulin that was found?
I don't know. I mean, I don't know if that connective tissue is there, but let's assume for the sake of argument, I don't believe that would affect the Fourth Amendment right to seize something. I don't know if they got a warrant or if they just went in there on an exception to the warrant requirement, because the remedy for a Miranda violation is suppression of the statement. I don't think it extends to the suppression of the evidence.
You may be right. I mean, I don't know, Bob. You may be right. I'm trying to figure out why in the world would the defense object to her statements coming in, to your point. Thank you so much. I love your expertise. Thank you for joining us.